Today's the date and time set for a preliminary examination, and then there was a PA 53 contempt arraignment. Okay, and this was a request to adjourn on the preliminary examination.
That's correct, Your Honor. We were scheduled today for both those hearings. We had submitted a stipulation and order requesting to adjourn. My client has had fever, chills. Had fever symptoms, aches, and cough. He has living with somebody currently, as he can't be in his residency. He's been living with somebody who has tested positive for COVID. Rather than appearing in person, we had requested to adjourn this out. I know there was an issue last week that we put on the record. We had submitted something, I believe, to your staff, hoping that the court would agree to that. And we'd also asked the court if it would consider, because of his being evicted. I know there was an issue where he wasn't allowed to go to work for a few weeks due to the tether zone. It overlapped with his employment, so he wasn't able to get paid. He wasn't able to make payments, and they've now evicted him and the AV in this matter from their apartment. And we would have asked if he would be allowed, even with an escort, perhaps, if that would be necessary, because their stuff's going to be put out on the street. I think as early as Monday or Tuesday next week, the writ could be issued. They got the 10-day notice thing, is my understanding.
Okay, did you say that he wasn't able to go to work, and so that's why he got evicted?
Part of it was there was this overlap with the GPS, and he was definitely making payments, but he wasn't able to go to work because of the overlap until he could get in front of the court and get that fixed. Judge Ward did fix that last week so he could go to work again. And now he's back at work and making money again, but he fell behind again on his payments, and now they have officially evicted them, is my understanding.
Okay, I was gonna say, I don't think his eviction had anything to do with his GPS zone. He was just arraigned on this matter on March 9th. And that eviction was likely already pending. He was probably already well behind. He already got a writ date.
I think they were on some sort of payment plan, Your Honor. I don't do the landlord tenant stuff at all. I didn't do that even in private practice, but I believe he was on some sort of payment plan. He missed the payments because he wasn't able to go to work until he could get in front of the court. That has been fixed, but now that is coming up rapidly to where he's going to be removed. So we're trying to get his stuff out of there before the actual writ is executed and they take the stuff to the curb. So that's why I had submitted a stipulation and order request.
I don't see a stipulation order.
You got sent late last night, Your Honor.
Oh.
But the people would stipulate to the fact to allow him to retrieve his stuff with an officer present.
Okay, and then as to the violation, because he's on GPS tether, I think that Judge Ward amended the exclusion zone to be reduced to 1,250 feet, which if the original 2,000 square feet was within his work zone, that his attorney could have made that request on the 9th, 10th, 11th, or 12th to have that amended so that he could go to work. There's no way for the court to have known, and there's no note here from the magistrate that when he was arraigned, he notified her that that exclusion zone fell within his proximity of his job. Also, don't even see where he even attempted to enter into that, and then he was notified that it was within the exclusion zone. So it doesn't even sound like he tried to go to work and that he was violated because of that. That doesn't look like it was an issue. Nonetheless, I do have a violation here alleging that there was more than 21 phone calls in violation of the no contact order. And so there was a no contact order issued on March 9th to you, Mr. Kane, are you there?
Yes, I'm here.
Oh, okay, there was a no contact order, which you were advised of by Magistrate Milmore back on March 9th, says you were not supposed to have contact directly or indirectly with the Anitris Morris. And that included contact by a third party. There's an allegation of jail calls between March 8th and 9th. And the 9th and the 10th, while you were allegedly lodged at Ingham County Jail, that there were multiple phone calls made in violation of the no contact order. So you have the right to have a contested hearing on that. You have the right to have the prosecution put forth evidence to establish beyond reasonable doubt whether or not you violated the terms of your bond. If you are found to be in violation of your bond conditions, your bond can be revoked. You could have to sit in jail pending this underlying case. Do you understand that?
Yes, I do. And I have one other thing to add to your, I notified the public defender's office about the,
you want to add what?
the, me to go back to the exclusion zone. I notified the public defender's office immediately when I seen that it was in the area where it said that I couldn't go to the GPS tether. I have emails to back this up, and was told by the other attorney, Jacob, that there was not going to be a hearing. They couldn't get a hearing, and that I had to wait until the previous hearing to do anything with it. I was out of work because the public defender's office refused to file anything. And I have the email conversations to back that up.
Okay, that'll be noted. I mean, that, I'm glad you noted that on the record. I just wanted to make it clear that the court was never notified of that. So the court could have amended the bond a long time ago.
Yeah, that's what I want to get on record, was they were notified many times and tried to get them many times to file something so that I could go back to work. But they didn't do it and forced it to wait until the prior hearing to do anything, because they just didn't want to do it, because they said that they couldn't get a hearing, and probably about 300 other excuses of why they couldn't do it.
Okay, so we'll enter a plea of not guilty on your behalf for the PA 53. We'll set that for a hearing. I do now have the stipulation in order to adjourn the examination. Let's see, due to COVID, doesn't address the 21 days. So, Mr. King, you have the right to have your preliminary examination in this matter within 21 days of your arraignment, and that is what caused it to be set for today. But due to the fact that you have been exposed to COVID and that you're experiencing COVID-like symptoms, I'm going to find good cause to adjourn, because we don't want you to come in the building with COVID symptoms, okay?
Yes, ma'am. That's why I alerted the attorney as soon as possible.
So we'll get you a new date beyond the 21-day timeline. Hold on a second. 27. April 27th. April 27th at 8:30. That'll also be the date of your hearing on the alleged bond violations, okay?
All righty.
Do you have any questions?
Yeah, they're saying something about going to my apartment to get the stuff out for the eviction, where I missed the payments, where I wasn't at work and had missed the agreement. I'm not having an officer sit there while I get our stuff out of there. The officer is not going to be happy. They're going to try to rush, and I have to pack an entire 2-bedroom apartment up, and they can't rush it.
Okay,
And as
so
long
this was an address that you resided at with the alleged victim, is that what you're saying?
Yes, all of our stuff
And
is
you
there.
both were evicted?
Yes, we were both evicted
Okay.
because I'd missed the
Mr.
payments
Ring?
because I couldn't go to work.
I'm gonna order that Mr. Ring work with the victim because I agree that an officer doesn't need to sit there while you pack up an apartment. That's not a good use of public
That was
dollars.
my fear. They're looking at a lot of hours, a lot of man hours sitting there doing nothing but,
So you need to
twiddling their
work with
thumbs.
your victim so that the victim relieves for a reasonable amount of time so that he can get his stuff.
Will do, Judge.
Okay, and then the attorneys will work together to communicate that time frame to you, so you know when you can do that, okay?
Okay, yeah, we have till April 3rd at 4 PM to have all of our stuff out, or it's on the curb at 4 o'clock is what they're saying.
We have all that eviction. Do we have that eviction file? What's the address?
5031 or 5831 Richwood Street, apartment 5, 48911.
3rd. April 3rd is Monday.
Monday.
I'm gonna get the, hold tight, I need to get the file, I'm gonna have to extend the writ. Because it's Monday.
Yes, I'd been saying the same thing to the prosecutor's office too, or not the prosecutor, sorry, the public defense office too, and they wouldn't file anything whatsoever to try
Well,
to
they don't
expedite.
handle,
it
they
because of
don't
this.
handle evictions over there, so I can understand why they probably didn't want to touch that. But we can get it taken care of now, sir.
Okay, yeah, no, it wasn't even to get them to touch the eviction. It was to get them to file for your court so that I could get in there and start packing. Not anything to do with having them go to an eviction court. It was for them to come into your court and say, hey, here's their eviction. It's April 3rd at 4 PM. And I've been diligently on this, trying to get them to file anything to expedite a hearing with.
You know, I'm not gonna sit here and just get thrown on the bus, Judge. I asked him specifically to send me a copy of this writ. He didn't do it. I said I'd file something as soon as he gave it to me, and I never got it. And quite frankly, I don't need to sit here and have him bad mouthing one of my attorneys who's been answering his emails and corresponding him for a week and then copying me on them. It is what it is. We don't do landlord tenant work, and I explained
We'll
that.
get it taken care of. I'm getting the file brought up now. I will go off the record while I get that file. Okay. You can proceed it. We're back on the record in the matter of John Kane. I'm first going to address the fact, Mr. Kane, your lack of, or your eviction has nothing to do with this case. You were supposed to make payment by February, and the affidavit of non-compliance said you made 0 payments. And that was before you were even arraigned and there were any bond conditions. So your bond conditions did not prevent you from paying your rent, sir. That's number one. Number two, I did get Judge Flores, who is overseeing the eviction file, to extend the writ till April 13th so that the prosecutor and the public defender's office can make arrangements so that you can go in there, pack up your things and get them out without the protective party being there. Okay?
Yes, okay. Have a problem with my phone.
No problem. Do you have any questions at this time about that?
So I'm able to, when will I be able to go and retrieve everything out of the apartment that's got to be packed up?
Okay, well, consistent with my last statement was that the prosecutor's office and the public defender's office will work out a timeline, and they'll notify you as to when you can safely go in there to do that without having the protected party in that space, okay?
Okay.
Mr. Rang, you can just direct the emails to me and I will oversee it and keep in touch with Mr. Kane myself, since Mr. Sartz is unavailable currently.
Sounds good.
And I check my email all weekend. I'm sorry, Judge.
Nothing on the field.
Nothing from the
Thank
defense.
you. Thank you.
Thank
You're
you,
all
Honor.
set, Mr. Kane. We'll see you on April 27th.
Okay.